to give some thoughts.
Sure. Okay, so since Howard bases his entire principle on the fact that we are entering a deregulatory cycle, I think it's important for us to be able to measure whether and to what extent are we in a deregulatory cycle. And part of the statistics that he included was about Obama, saying that Obama actually promulgated the fewest number of rules since 1980 and engaged in extensive regulatory repeal. Now, the fact that I was surprised by this indicates two possibilities. One is that the number of rules that are promulgated is not an accurate measure of how regulatory an administration is, and we should be looking instead at the enforcement of existing rules. Or the second is that the public doesn't really have a good sense of whether we're in a regulatory cycle or a deregulatory cycle. And there's a lack of transparency and political accountability for how much regulation is actually happening. I am a bit concerned that absent campaign finance reform, we may in fact be in a perpetual deregulatory state, and that this idea of cyclical regulation may not be true as long as most politicians are accountable to the corporate donors for re-election. So I think that's a question worth asking, whether deregulation is indeed cyclical, and whether if we're going to say we need to have more robust antitrust enforcement during times of deregulation, then we need to have a way to measure whether it is actually a deregulatory period and what gaps are being created. But I'd also like to point out that robust antitrust enforcement cannot just fill gaps that are left by antitrust, by deregulation, but it can also be used to stave off enforcement. To stave off regulation. So, for instance, for the Capital Forum, I have been writing about competition and Google, Apple, Facebook, and Amazon. And there's been really not much enforcement in terms of Section 2 enforcement against these growing platforms. I've written about something called platform privilege, where the tech giants they have the incentive and ability to prioritize their own products and services on their platforms. And there really hasn't been any antitrust enforcement or Section 2 enforcement in this area in the United States. We're seeing some in Europe. And I think that if we did look at some more aggressive measures for antitrust enforcement regarding tech giants, we might actually be able to stave off some of the bigger calls that we're having for regulating them, like utilities, for example. So I think we need to think about that as well, not just filling in the gaps that are left in deregulation, but also the role that antitrust enforcement can play in actually staving off regulation. Howard also talks in his paper about the debate about which is better, regulation or antitrust enforcement. And I think the answer is really that it depends. There are certain examples where antitrust enforcement, I think, does not work, and a good example for that is net neutrality. We really need ex-ante rules for net neutrality, and those that argue that antitrust enforcement will be the solution if we get rid of net neutrality rules, I think don't understand that a startup does not have 5 years and hundreds of thousands of dollars to use to try to pursue any claim of improper treatment against an ISP. So I think in the example of net neutrality, we definitely have a situation where regulation is preferable. In other instances, I had an experience when I was an antitrust enforcer at the New York Attorney General's office, and I consulted with a local agency about a merger review, and they actually had in their statute that they were supposed to do antitrust analysis. They had no antitrust expertise, and they just didn't do it as a matter of practice. They also didn't have much of an interest in doing it because they were largely captive. So in those circumstances, antitrust enforcement is actually preferable to regulation. So I think it's a very important point about Trinco and Credit Suisse and how the doctrine of implied antitrust immunity has been expanded so much that it causes a problem where it's putting them as substitutes instead of complements. So the fact that each tool works better in different circumstances is not accommodated by that framework. And I fully support the point that Howard makes that in a time of deregulation, this is an opportunity for enforcers to bring cases to try to clarify those cases, Credit Suisse and Trinco.
Thank you. Now, bringing up Nancy Rose, the Charles Kindleberger Professor of Applied Economics at MIT. Tell us about monopsony, bargaining leverage, and buy-side benefits. Oh. Mm-hmm. There you go.
You should have fixed the clickers over there. They're putting the batteries in. Let's just see this one.
Yeah, great.
Awesome.
Okay. So when I was at the Antitrust Division as a deputy, I was told I couldn't make a disclaimer that I didn't speak for the DOJ, since inherently by my position I did. Now that I'm back on the outside, I'm going to try it again. Given that Scott is on a plane to NYU for a longstanding commitment that he has there, I would like to say I'm speaking just for myself and not for my co-author, so my views may not always reflect his. And should I run out of time, I want to give you the takeaway of our paper, again, without maybe specific attribution to my collaborator, which is that in keeping with the legislative origins of the Sherman Act, with an extensive and ever-increasing body of cases and case law, there should be no question but that antitrust law protects suppliers from harms to the competitive process in the same way that it protects consumers from harm to the competitive process. And what I'd like to do is to walk you through our analysis. So let's start with a pretty simple context that I think is probably fairly comfortable and well recognized. And we'll think about an increase, we'll think about horizontal mergers, although sometimes I'll refer to cases that are drawn from collective act or cartels or collective action among horizontal rivals. So we'll think about a case where there is a merger that increases market power upstream. We'll call that increased monopsony power. And we'll think about how that might affect price and quantity in the input market and potentially in the output market. Compare that to our traditional horizontal merger case, in which the merger increases market power downstream. We think of that as increased monopoly power, and sort of how do we analyze those. So in a monopsony context, and in this particular situation, let's think about the merger primarily reducing competition either upstream if it's monopsony or downstream if it's monopoly, but where the parties may also have some market power on the other side of the market. So in a monopsony case, we think that the merger of these two buyers will lead to a situation in which the input prices will be pushed down, suppressed by the monopsony effect, and input quantities will be reduced. In the monopoly case, the kind of symmetric case on the other side, the effect is that the reduced competition increases prices downstream and reduces quantity. And there may be effects in both of these on the other side of the market. So in the monopsony case, if the firms also have some market power downstream, then this reduction in their quantity purchased of inputs may also lead to harm in the downstream market, higher prices, lower quantity. We don't talk much about it, but you could imagine the same thing going on in a traditional downstream horizontal merger case, where by reducing the quantity that they're producing for sale in the downstream market, they're also demanding less inputs, and if they've got market power in that market, suppressing input prices as well. So as I said, I think this is something that we're reasonably comfortable with, and there's a pretty significant body of either challenges to horizontal agreements in the monopsony market, which is what the focus of our paper is going to be, or in the upstream market. So think of the Silicon Valley no-poach cases, kind of hospital nurses cases. There are even some monopsony merger challenges. So think about the Aetna Prudential insurance case that the DOJ brought, or recently the settlement in Danone Lightweight that concerned this kind of monopsony power. I think the trickier case for some people is to think about where the other side of the market, so we're thinking about, again, mergers between horizontal competitors that might have these upstream effects in monopsony cases, downstream effect in monopoly cases, but where the other side of the market's competitive, right? So in this case, there would be input price and quantity effects from the merger, but not necessarily any output effects. So think here a grain elevator or merger of grain elevators in a local geography where they exert monopsony power over the farmers in the area, but they're selling into a global grain market, such as the case in the Cargill merger that DOJ opposed a while ago. Similarly, in a monopoly case, there may be downstream effects without any upstream effects going on. So what can we make of this? And this is where sometimes there seems to be some reluctance to say there's harm in the upstream merger case if we can't show output reductions. But in fact, we know from case law that that's not necessary. So Weyerhaeuser, which is a predation case, but nonetheless looking at upstream harm, basically makes the point that harm limited to input markets is actionable under antitrust laws. Similarly, Mandeville Island Farms, which was a collective action, a cartel against sugar beet farmers, also made the point that buy-side harm from the cartel is actionable. And then finally, we would argue that symmetry between the upstream and downstream markets suggests that you should not have to prove an output reduction in the other side of the market to have actionable harm. All right, the next case that gets a little bit, maybe steps even one more place outside of people's comfort zone is the case in which we're not looking at monopsony, where firms are just moving along an input supply curve to decide how much to purchase, but instead where prices and perhaps quantities are set through some kind of negotiation process. So here, think about not atomistic participants on the other side of the market from the merging parties, but rather large buyers, perhaps negotiating with large, or at least not atomistic sellers. And the canonical example of this might be two hospitals in a particular geographic market merging. And I say canonical both because it's a great economic example, but there's also now a quite substantial body of case law developed through FTC challenges that talk about bargaining leverage being actionable and being a harm, again, to the competitive process. What's important for it to be problematic, to say there's a harm to the competitive process, is that the merging parties are indeed competitors. And one way to characterize that in economics terms would be to say that they're competing if the value to the insurer, in this case, of adding another hospital to the network is diminishing as you add more and more and more hospitals to the network. And so hospitals are essentially competing to add value to the insurer's network. In this particular example, if we thought about a single hospital, H, negotiating with an insurer, the surplus that the insurer would have, the extra value to the insurer's network, from adding that last hospital is denoted by M on this graph. And so if you think that the negotiation process basically splits the gains from trade, then you think that the insurer and the hospital will each take away 1/2 of M. But now think about two hospitals merging. In this case, the two hospitals go to the insurer as a unit, and they say, we're going to negotiate, you take either both of us or neither of us. And now the hospitals can threaten to leave the insurer with a reduced surplus of M plus N if they don't reach an agreement, which is larger in the way that we've drawn it, given the shape of this value function, is larger than twice M. And so essentially what the hospitals have done by this merger is enabled themselves to extract more surplus or more value from the insurer. Whoops, sorry. So if we think about this case of increased bargaining leverage, that's in the output market, but you could have something equally symmetric in the input market, where in the input market the price would be pushed down. You could think about this as the harm that was alleged, one of the harms that was alleged on the buy side in the Anthem-Cigna merger case. Corresponding to in the downstream merger case, the price would be in the output market would go up. There may or may not be an output effect. It's not, some economists will say, well, there's no output effect because of efficient bargaining. I would note efficient bargaining is an assumption, not a theorem. But just as before we argued that you don't have to have an output effect in monopsony, you don't have to have an output effect, we would argue, in this context. And ProMedica basically makes that point. The ProMedica decision points out that increased bargaining leverage in the output market is actionable without needing to show any quantity loss. And we would argue basically by symmetry that the same would apply upstream. Finally, what about the benefits of lower input prices? Are those somehow something that should be offset if they are passed along to consumers, to final consumers? And what we basically say here is, to the extent they're true efficiencies, a reduction in resources because of, say, some scale economy in serving the particular buyers, those would go through the traditional efficiency analysis. You'd have to make sure that they met the conditions for consideration, but you would include those. 30 seconds. Sometimes there are pecuniary cost reductions that might be considered. And I think of those as like the affiliate contracts in the Anthem case, where there's no resource saving, but they're not the result of reduced competition. But we make the argument that, just as the appellate court did in Anthem, that if those cost reductions were to be derived from a reduction in competition, they are, in the words of the dissent, but a similar view echoed in the majority opinion, the fruit of the poisonous tree, and they're not available as a defense to an otherwise anti-competitive merger. Thanks.
Thank you. Some commentary from Debbie Feinstein from Arnold and Porter.
Thanks. It's a pleasure to be here, if not a little daunting. This is not a subject that I think that we spent a lot of time thinking about at the agency. It didn't arise all that often. It sounds like it came up more at the Department of Justice than it did at the FTC. We certainly had occasions where we would think about it and very quickly realized that the facts just did not suggest that this warranted a case. But let me, and the other thing I think that's an issue here is that there isn't a lot of empirical analysis around this. You look at the bargaining leverage theory, which has now very much taken hold. But the issue is that we only got courts to accept that after showing some real empirical cases where we could show that hospital mergers led to increased prices. And I realize there may be some older cases. I'm a little more dubious that the current state of the law is such that folks could run in with a monopsony case that just showed a price increase and no output effect and get the courts to accept it. I think the courts have enough trouble with simple horizontal cases to get to that leap quite so quickly, but we'll see if the right case comes along and actually gets litigated. I want to take each of the three cases and just talk briefly about the monopsony issue, the bargaining issue, and the efficiency issue. On the monopsony issue, I think the antitrust authorities are going to have a hard time thinking that they want to bring a case just based on a price decrease. I'm not sure that a price decrease alone will suggest that that is necessarily harm to the competitive process. And the reason I say that is, supposing there's a price decrease, what is the result? What is the impact of that price decrease to an input supplier going to be? Suppose that all the input supplier does is becomes more efficient. Nobody goes out of the market, no output is reduced. They become more efficient because they've been forced to. That does not strike me as necessarily harm to the competitive process. Maybe there would be an issue on output and on quality. In that case, I think one could make an argument that there is harm to the competitive process, and those are the kinds of things that one would look for if you were looking at these cases. Of course, if you're two input suppliers and you're creating harm to your suppliers by reducing the number of competitors because you're causing them to decrease output, go out of business because they can no longer make a profit, or reduce the quality, query why would they do that? They have the ability to stop the harm to that competitive process, and the question is that really sensible to think that they are, and it may be, that they are naive or stupid and will harm the very supply input to themselves? I mean, I think these are all issues that you'd have to think about in thinking about whether or not there's, in fact, harm to the competitive process. I think there could be an issue of short-term versus long-term. Very much the merging parties may just see the short-term effect of, I can get a better deal, I can get lower prices for why I'm buying this, and not think about the longer-term impacts, and therefore not think about the ultimate effect. But I think the agencies in telling a story would likely want to understand all of that before they simply said, I think prices will, input prices will be lowered, and that is necessarily harm to the competitive process. The second issue on bargaining, I think it's pretty clear that the story that Nancy laid out about hospitals and getting increased bargaining leverage is one very much that works. Flip it, though, on the monopsony case, and I think you ask a lot of the same questions that you ask with just the general monopsony theory. Imagine beer companies who negotiate to buy cans, and they're trying to get, as a result of a merger, put aside what the downstream effect would be on a merger of two beer companies, what would the upstream effect be? I have trouble sometimes differentiating the reason that the beer companies might offer a bigger deal to a merged company than that of exclusive dealing. I'm just offering you something more, which was the ability to basically contract for a bigger set of needs, and therefore you may offer a bigger price to make sure that you're filled up, to make sure that you only have to deal with one supplier. That may be bargaining leverage, but it also may be that I am giving you something of benefit by being a bigger company, because I can promise you a longer-term deal, better economies of scale, better ordering, all of those sorts of things. And I think you'd want to understand whether that's really a shift of bargaining leverage or just an efficient way to do something that is more interesting to the input suppliers. I'm seeing the time watch, so let me just say something quickly about efficiencies. Again, if this is just rent shifting and there's no output quality effect, how much should we care about the fact that this isn't efficient cost outs? I don't know. I mean, I think it goes to your question of how much you believe that efficiencies are going to be passed on, and whether there are, in fact, a reduction in cost. Because if there's no harm to the competitive process at the input level, and there is the possibility of efficiencies and pass-through, I think that's something that folks are going to grapple with. I think in the real world, in most cases, there's a lot of skepticism about efficiencies and pass-through, given the kinds of deals in which you're actually fighting about efficiencies. But I think that is going to be a tricky issue to confront if the agencies look hard at most monopsony cases. Thanks.
Thank you. All right. Bring everyone up now, or can we bring everyone up now?
No,
or
bring everyone up after.
Okay. Yeah, right. Stay back.
Everyone's
coming up.
Come up.
It's gonna be fun. Why not?
I don't want you to be lonely up here. So before I give my comment, I just want to say you've seen that the discussants have seen the draft of the papers. We haven't posted them all. They're not. Some of the authors have, and you can find them on Red. But eventually, we'll put them up in some fashion on a site that has the recordings posted as well, and they'll also all be published eventually in the Yale Law Journal. The papers. So
this conference is being recorded, so if you loved it so much you want to watch it again, you're going to be able to do that. Or tell your friends.
Very exciting.
All right, so now to my comment. What I want to do is explain why the papers and the session and the conference as a whole are important, without specifically talking about the three papers that we just heard. We have today in in this country, we have a surprising conjunction of substantial market power in the economy with well-established antitrust institutions, and that's a paradox. You all know about the institutions, but I want to go quickly through 9 reasons to think that there is concern about market power. None of them are going to be decisive individually, but if you look at them collectively, I think they're persuasive. And I thought about putting up slides to show you that what the research, the articles I'm relying on, but it's too short a time and too hard to do that. So I'm just going to talk in a general way, and we can talk about the research if you like in a bit. And I'll just do the headlines. So first, we don't sufficiently deter anti-competitive coordinated conduct. We don't do enough to deter express cartels, because they're a steady state and there's no efficiencies from them, and the damages are probably too low, and that's probably easier to deter express cartels than it is to deter tacit collusion in oligopolies. So we probably have too much of that too, and that's probably more important overall. And second, we don't sufficiently deter anti-competitive mergers, and that's a conclusion based on merger retrospectives of close calls and a systematic study of manufacturing mergers that's recently in the economics literature. Third, we don't sufficiently deter anti-competitive exclusion, and that's a conclusion suggested by recent research on the anti-competitive consequences of vertical restraints, which aren't quite the same thing as exclusion, but there's it's more of an exclusion category than horizontal restraints. And it's also suggested by the fact that the rules that govern exclusionary conduct were relaxed the most when the Supreme Court adopted the Chicago School of Views beginning in the late 1970s. Fourth, market power is durable. The average cartel that's been cut short by antitrust enforcement lasts 8 years. Cut short lasts 8 years, and with many going on decades. And even when there are near monopolies that have eroded over time, and you can think about General Motors, IBM, Kodak, RCA, U.S. Steel, Xerox. All those positions have often persisted for decades, and we can't expect the market to correct market power problems itself. Fifth, there's been a huge growth in the ownership of competing firms by diversified financial investors, and there's research showing that the result of that is less aggressive competition and higher prices. And Herb Hovenkamp and Fiona Scott Mortner will talk about this in their paper after lunch. Sixth, many of the platforms that have been developed by information technology firms that have become large in the recent past are probably insulated from competition in some of their major markets by all sorts of things like intellectual property protections, the absence of divided technical leadership, network effects, all kinds of things. Price-cost margins have gone up a great deal over the past 3 decades, and that's probably attributable to a combination of market power and scale economies by firms that have invested in information technology, not just those platforms, but throughout the economy. Seventh, oligopolies are common and concentration is increasing in many industries. Now, over the past decade, about there are various industries that we know about where concentration has gone up, and we have studies showing that firms exercising market power. And I have in mind airlines, brewing, and hospitals, for example. Now, there's economy-wide evidence on concentration. That's not so strongly informative, but it's consistent with what we know from industries like these. Eighth, over a span of decades, a number of governmental restraints on competition have grown, and I don't need to go into that. Occupational licensing, scope of patents, the citizen petitions at the FDA, various issues like that. And finally, we've seen a long-term decline in economic dynamism, and there are all sorts of aspects of that, like lower rates of startups, slowdown in business investment, various things. The profitability increasingly going to the largest firms, productivity improvements increasingly being among incumbents, not by entrants. The most important trends are probably the secular slowdown in business investment and a rising share of GDP going to profits, or at least those are the ones where market power is a leading explanation. It's a plausible contributing explanation for some of the rest of the trends. So why do I think all of this reflects growing market power rather than the results of a technological shift to higher fixed cost methods of production, perhaps involving information technology that raises price cost margins in a largely competitive economy? Well, the premise that scale economies have grown from large fixed investments in information technology is probably correct. But growing scale economies can't explain 6 of those 9 reasons that I just went through. And they can't explain the insufficient deterrence of various kinds of anti-competitive conduct or growing common ownership, for example. And at best, they're only a partial explanation for the others. It's hard to ever really rationalize that scale economy story fully with the declining economic dynamism, for example. So market power has probably been on the rise for decades. But if you actually looked at the research that I'm talking about, the articles that I haven't shown you, you'll see that a great deal of them are recent, the last few years. So the scope of the problem is only now becoming clear. And so that's why we're here talking today about ways antitrust enforcement can address market power more effectively and deter its future exercise.
Fantastic. Thank you, everybody. As we start out, I just thought I would first see if any of our speakers had an urgent desire to respond to one of the discussants on their papers. Anything?
Nancy, do you have anything you want to say?
Please.
I'd be happy to respond. So,
Okay, go for it.
can I make just 3 quick points? So first, of course, if there are, and you say more about this in the paper, but of course, if there are scale economies to serving a buyer, then there may be real efficiencies from getting bigger, and that may lead to lower input prices. The harms that we were talking about are harms that are resulting from a reduction in competition, not from an increase in scale economies, and you should understand that. You need to understand that if you're going to bring a case in this space. I will say I think there are very different reactions by suppliers if they think, oh, this new merged company is going to be a lot less expensive to serve. That's kind of a good thing for me, as opposed to this merger reduces competition for my services or my products, and that's a bad thing for me. The only other thing I just wanted to say is, why should we worry about this? I think we should worry about workers, about farmers, about nurses, about suppliers of all kinds upstream if they're being harmed by the competitive process. As I said, I think that goes back to the very origins of the Sherman Act. I think that goes back to a large number of cases that have been decided. And I think there's just this deep-seated confusion that somehow it's only whatever a final customer pays that should matter to the antitrust enforcement. I just don't see that as an argument. And then the last point I would just make it with Debbie's question of why would firms harm their upstream supply chain. I hear the same thing from parties saying, why would we increase price to our downstream customers and hurt them? Well, I think we know the answer to that, and I think it's a symmetric answer upstream as well.
So I have a few comments. For those of you who have forgotten, the paper with Herb was about horizontal mergers and the structural presumption. Thank you for your comments, Josh. I have two reactions. First, I totally agree with you that the structural presumption is very important in court, but much less so at the agencies for their investigation. That's true. There's so many differences between agency investigation and what happens in court. I think appropriately so, different expertise, different process, and so forth. So, and in fact, when we revised the merger guidelines, one of the things we did that got people's attention was we started with this discussion of what's the evidence about effects, and then later got to market definition. A lot of longstanding antitrust attorneys are like, how can you even do the analysis until you first know what the market is? Well, it turns out the agencies have been often figure out what the market is later once they figure out the effect. So I'm really talking here, we're talking here about what happens in court. Okay, and it's quite different than what happens in the agencies. The other thing, you brought up unilateral effects and differentiated products, and I guess you said as a threat to the structural presumption. I kind of see where you're coming from. We do have a section, a couple pages in the paper on this issue, which I didn't talk about in my short time. But I wanted to say this, which is if you, one of the things that I think the economics has advanced, and it is in the 2010 guidelines, is kind of reconcile what happens with unilateral effects with market definition. That was very confusing, I think, to Judge Walker in the Oracle case, and the decision's kind of confused about that, and obviously the DOJ lost that. But as they say in the paper here, it really relates to hypothetical monopolist test. If the merged firm would find it profitable to significantly raise price unilaterally after the merger, then the hypothetical monopolist test, as applied to the merging firm's product, will be satisfied. So you can actually have quite narrow markets. Now, the government probably won't allege just such a narrow market. They can allege a broader market, and that's fine. But there's the guidelines explain the consistency, and so there's the use of those tools for unilateral effects should not, in fact, undermine the structural presumption.
Yeah, I mean, just very briefly, I completely agree.
Good, we stopped.
And the text Carl was reading was prefaced by the word happily, that you can reconcile a merger of A and B and a price increase and sticking it in the hypothetical monopolist test. My point was that dynamic, I think, had Oracle continued, would have been a big problem for the structural presumption. If you go through that opinion, it just says this is wrong. And what the agencies did in the Obama administration with enormous decisiveness and focus is push that methodology as the right way to define product markets, got the judges to agree, and then, excuse me, when they got to the competitive effects section, they were good to go. Most of those opinions rely on addition and squaring for competitive effects analysis. They do not do diversion analysis. So I think the agencies have dealt with that issue. My only point is that if I were contesting a structural presumption, I would not go back to those original studies. I would say on pages 12 and 13 of Carl and Professor Hovenkamp's report, it kind of says in substance those market shares really aren't all that relevant when you do the economics.
So I wanted to ask a perhaps completely ignorant question of Nancy and Debbie that came up in your discussion. I think one of the things Debbie had said was that, well, if the impact on suppliers is that prices go down and they're forced to be more efficient, that's not a harm, presumably because efficiency is good. But I was thinking about that myself as a, I don't know, supplier of things. And you know, I'm here today, this afternoon. I'm not sure that's a very efficient use of my time from the standpoint of the firm that employs me, but I like to do things, go to interesting events, learn. They like to, you know, let people do stuff if they can. And if we were forced to become more efficient by a change in the market structure, it seems like that could be a real harm to us and to our interests. And, you know, is that something that we should think about? I mean, of course, will you decide to be more efficient, that's one thing. But if we're saying, well, a merger of some people downstream from us is going to force us to change our practices and become more efficient, you know, should we be able to say legally, policy-wise, that that's a harm to us?
So I guess I would just first start with the premise, which is, you know, why are the firms not supposedly efficient in the first place? And I think our position is it's some level that argument a bit reminds me of the argument that Anthem made in the Anthem-Cigna merger, which was, look, you should love this because we're going to squeeze down those hospital prices upstream and they're not at the competitive level, and we'll get them closer to the competitive level. I think this is a very similar argument. And what the district court judge said, and more or less consistent with our view as well, is and with a number of other court decisions, is it's not the job of the court to decide the efficient organization of the healthcare sector, just as maybe it's not the job of the court to decide what's the efficient set of or socially optimal set of incentives that firms may have or may not have. That's really complicated. Even, you know, economists who have the luxury of unlimited time probably have a difficult time coming up with the answer to that question. And I think that's why, if you look at many of these cases, the judges come back to saying if there's a harm to the competitive process, that's what, we're able to sort of decide on the basis of that. We can figure that out. Maybe not so much the socially optimal organization of the economy.
Yeah, but I think the tricky thing is, what if some of the suppliers say, I don't see an issue, and others do because they are more inefficient and it will hurt them more? I think that's a question of whether or not you've got, harm to a single supplier or you've got harm to the competitive process. Right. And, I just don't know how a court would come out on something like that. Carl's looking at me like he wishes I hadn't said that.
Well, I think all this stuff about monopoly, test your arguments by turning it upside down and seeing what happens. So suppose you said, you're going to have a merger and it's going to raise the price to the suppliers over here who use the input a lot, but these guys use the input less, and so they're perfectly happy. You still wouldn't like that merger because some of the customers are hurt, even though others are advantaged. So you've just violated that in the upstream version, I think.
Right, and so the question becomes, do we care about upstream for upstream's sake, or do we care about whether it, all of these upstream arguments, right, raise the question of how do we balance upstream harm versus a possible downstream benefit of efficiencies.
Okay, let's bing over here.
Can I just offer a view about this issue, about the two papers on which I have not said anything? Yes. Look, as a matter of litigating, if you're writing the complaint for the government or a private party, Debbie makes an important point. One would like to be able to say bad things are going to happen, and so in the Anthem complaint, for example, there's an allegation that the lower prices to hospitals and doctors is going to lead doctors and hospitals to produce less, okay? But that's different than the question of legal sufficiency. And here's where I think the paper from Carl and Professor Hovenkamp have direct application to the buyer side issue, which is we ought to also be thinking about our structural presumption work from the buy side, right? And Peter Carstensen has written about this and how it might work, because there's no particular reason, assuming the symmetry to which Carl just refers, that there won't be some set of market conditions or market concentration that should trigger the same presumption. And while that is only a litigation change of effect on the burden, it does allow the government to establish a prima facie case, given particular forms of concentration, and put the burden on the defendant to then come forward, which I think may flesh out some of the issues to which Debbie avers, right? So I think this is also an important part of the conversation.
Right, I'm just saying, even if it's not an efficiency as an economist would describe it, the parties will say, should it matter whether I get my cost curve changes either way, right? My cost curve changes if I get really good efficiencies. My cost curve changes if I've got monopsony power, right? I mean, the cost curve doesn't know.
If it's just a straight monopsony story, then in fact, your marginal costs are higher because of your increase in the upside market power. The price you're paying suppliers goes down, but you perceive that price to have a very high marginal cost because buying the next unit of nursing services is not just the wage you pay that nurse, but it's the higher wage on all of the other nurses that you're paying. So in a straight-up monopsony case, there's no argument for a pass-through because the companies, in fact, see their input prices, their marginal input prices higher. So I think this is coming more in the bargaining context where it might be relevant. And I just have to say, I don't understand why we would say if you're gaining this through an anti-competitive act, Section 7 says substantial lessening of competition. If you're gaining it through a reduction in competition, why we should say, oh, but you can count it as a benefit in this other market.
I think it's just going to be a question for people as to whether or not you ought to look at the overall effect. I just think that there are courts who are going to find that appealing.
And this is where I'm suggesting the structural presumption may play an important role. Right.
I think Scott would say, if you don't like this, then you're either saying Weyerhaeuser's wrong or ProMedica's wrong. Because I think both of those decisions together are kind of getting at this core issue.
Okay,
I'm not saying whether it's wrong. I'm saying how I think that decision makers will react.
Sure.
Just briefly, operationally, these upstream cases are very hard to bring. As a matter of gathering the evidence, they are quite technically difficult. And if you think you have a better case in the downstream market, you are going to put your resources there. The Anthem case, John doesn't have to answer, there were tactical reasons for alleging the upstream case. I doubt very seriously they would have brought that case on its own were there not a significant downstream effect. And then I also think or alleged effect, I also think it matters a lot who the target and the vulnerable people are. That if the allegation were hypothetically, we're going to reduce the merger, will reduce the reimbursement, the rate of increase of reimbursement to very large hospital systems, and that is going to produce an anti-competitive welfare effect, I think that's a hard sell. Conversely, there are other industries where you're talking about individual people where it may be easier to do. So like a lot of these things, I think it's going to be a pretty fact-specific analysis where the viability of gathering the evidence rather than theory is ultimately going to determine what happens.
I was going to say, is the difficulty in gathering the evidence the fact that the companies that you want to complain about it are completely beholden to the dominant buyer?
Well, that's a great question. So to stick with the health insurance industry, again, unfair question to John. Did he have a hospital lined up to testify to say that if our rates of reimbursement only increase by 3% rather than 4%, quality is going to go down? I doubt it.
There were upstream firms testifying in that case.
I know. I just think it's hard to do.
And it's not just hospitals. It's physicians, individual physicians.
You're right. And so on the physician side, then the problem becomes, well, let's say in a typical market, there's 500 physicians. How do you deal with the problem of the commons of saying that, orthopedists 1, 2, and 3, when they testify, are actually providing indicative representative evidence for the cardiologist down the street and the primary care physicians one town over? It's not that it doesn't hold.
I'm not saying that the litigation is trivial. And in fact, in the paper, we point out that the reason there are so few of these cases, I think, is because often there is both upstream and downstream harm. And so it's easier, everybody's more comfortable with downstream, why get into the upstream? But I guess the point is, we shouldn't, that isn't where the agencies should be settling. If we think there's an upstream only harm, we should be worried about that. And you're right, it's challenging to bring those cases and to explain those before judges, but I don't think that's an argument for saying the antitrust laws only apply downstream.
So I think part of what's happened is we've been talking for decades about the consumer welfare as the objective. And when you've got sell-side power, that's the natural way to bring it alive. And it was very important, particularly in the 70s and the 80s, to clarify we're out for consumers, not about protecting competitors. So that language is very important. But if you go back to the history of the Sherman Act and really protecting competition, workers and farmers and suppliers who were subject to monopoly buyers were very much concerned. So I think there's no question of legislative history. I think it'd be a mistake for antitrust to ignore that and get so mesmerized by consumers. I think the right way to think about it is there a counterparty in a situation who's subject to having to deal with a monopoly or fewer alternatives? Okay, we're used to thinking of a consumer as a buyer who has to buy, that's the counterparty, it's a monopolist. Right. But if you have to sell to monopolists, it's exactly the same thing, and that's why I like the paper very much, is you cut through that. And so we should go there. There are actually a fair number of cases like this. I'll give one example just because I think it's illustrative. I worked on the BP Arco merger. This involved the oil fields up in the North Slope in Alaska. And they basically were selling the oil into, let's call it a world crude oil market. There were some questions about whether the West Coast market. But that was the sell side. But on the buy side, there were two firms who would bid for tracts of oil. And they were basically two of the only two who could bid for these tracts because they knew how to extract the oil and get it to market. Well, that was a significant reduction in competition in the market to bid for those tracts of oil. Now, maybe we don't care so much if it's a federal government selling the tract. I don't know, but that's the counterparty. What if it was a Native American tribe? Okay, would you feel differently? Okay, either way, there's a harm of competition in that upstream market, even though there was no harm, I would say, in the downstream market.
I mean, here, I think Jonathan's remarks about the sort of macro context are are relevant here, right? I mean, in the 1970s, you have a time of very high consumer price inflation, relatively low corporate profit share of the economy. It seems maybe natural to say, okay, we're going to make a consumer focus a number one policy priority. And as the broad economic situation changes, it makes sense to look perhaps at a broader set of issues. Yeah.
So if on the sell side, we have a consumer welfare standard, just for argument's sake, so that means that the only people who count are final customers and not firms, either the emerging ones nor competitors, is the analog then that on the monopsony side, the only people who count are workers? In other words, is there a distinction between two insurance companies merge and squeeze a hospital, but then pass along to consumers versus they squeeze those wages?
So I'll let the lawyers on the panel correct me if I'm wrong, but I don't think on the sell side, if we've got firms that are merging at an intermediate level and selling to other firms, I don't think that we typically go all the way through the input-output tables to calculate what Nancy Rose is going to pay more for some product. We just take that next level down. I think the same thing is true upstream. If the monopsony or the reduction in competition is coming about primarily in the labor market, we'd worry about labor. But if it's coming about from firms that are supplying those merging parties, I think we'd take that harm. I think that's the symmetry. But somebody should correct me if I'm not
But let me can I give an example? Somebody said earlier we ought to be giving some non-price examples. Here's a non-price example, right? There was a cable merger that was reviewed by the Department of Justice and the FCC a couple of years ago. And what the FCC found, and I think what the DOJ alleged in a settlement complaint, was that increased buyer power of the merger of two cable companies could lead to bargaining leverage that was used to get video programmers to restrict the ability of over-the-top competitors to come downstream, right? Now, that was a restriction of output in the upstream market, right? It wasn't going to people it could have done. And it was also demonstrating harm in the downstream consumer market, right? So these things are not in opposition to each other. But the fundamental point, and I agree, I think Nancy's paper is very helpful on this, is that one is looking for the constriction of competition as the critical sine qua non of starting the competition analysis, right? And that seems quite sensible.
Yeah, I just want to take it back to a remark Carl made or it was raised before. This is all about multi-market balancing and whether we're permitted under Philadelphia National Bank or under inextricably linked, whatever that means, efficiencies to balance harms in one market with benefits in the other. And that arises both in strictly horizontal mergers, it arises in vertical mergers, it arises in Comcast, Time Warner, and that's the question. Now, Philadelphia National Bank says multi-market balancing is not permitted, and if that's the case, then it's also clear that anti-competitive effects in any market violate Section 7 of the Clayton Act. So if you're starting from that, we're done. And Nancy's right. And your criticisms that consumers are benefited carries no weight. But and then we have footnote 14, the famous John Baker footnote 14. Well, if the efficiencies are inextricably linked, and there's no way. But if the harms are small and the benefits are large, then somehow we'll balance them. If it's likely to harm what they call consumers overall, whatever that means. So that's the question that we're facing. And I agree that saying it's a consumer welfare center, although I've certainly tried to popularize that, but that's not going to provide the answer. If we go with Philadelphia National Bank and what Section 7 says.
This is also a comment regarding the same thing. There's a long line of cases, in fact there may be 50 of them, that deny standing to landlords, licensors, employees, and other kinds of input providers, because they deny standing, they never reach the merits. So we really don't know if monopsony power or the opportunity for its exercise is present, because they all go off on indirectness and other things courts go off on when they deny standing. But based on what you said, I think we need to take a new look at those cases and get plaintiffs to explain their theories of harm a little better, and maybe start granting standing to some of those.
I mean, I think that's a great point. I could imagine, I'm not familiar with those. I could imagine a variety of allegations, some of which would fall into our categories and others of which would not. And it does seem really important to understand which are coming from a reduction of competition as opposed to, you know, these merging parties are going to shut down a plant and we don't want to lose our jobs, which may not be an anti-competitive effect.
So one quick thought on that. I agree that the doctrinal issues are something you want to work through, but in many ways, I think the harder issue would be that requires an individual, when he or she is making those decisions, when the lines count, to say, I'm going to decide that this bucket, the welfare of this bucket, which is not a consumer welfare standard, I'm going to elevate that above the consumer welfare standard, notwithstanding that hasn't been done before, and I'm going to provide an explanation as how I'm going to make that decision. You may get there. I think that's hard.
So the consumer welfare part, you will eventually get in the following sense. I mean, Debbie said, why would the two merging firms want to harm their input suppliers? So let's take some examples that we're familiar with, like chicken farmers, okay? The chicken farmers, you're going to harm them because you can make more money by doing that, and they have a sunk investment. Their chicken shed that is the thing they grow the chickens in. So you're not thinking about the firm has a manager who's going to retire in 5 years or gets a bonus quarterly or annually or something, and is not thinking about the next generation of chicken farmers who need to invest in sheds in order for chicken production to continue. So you eventually do get back to the consumer, because if all the chicken farmers are driven out, then there are no chickens and the consumers are harmed. So the consumer has an interest in an efficient market that gives returns, competitively priced returns to all the activities that are socially valuable, because that generates the set of goods and services in an efficient way that they want to consume. And if you think about movies, the cable example in movies, you get the same thing. Suppose I, pay nothing for movies anymore. Only people who, are doing it for a hobby are going to invest in movies rather than people who want a return. So I think you don't have to have this.
I think this is really important what Fiona says, because it may be that one can think about it this way, that particularly in a merger review, right, where there's a prospective look by definition and an incipiency standard by statute, one is not using a competitive process, if we want to just use labels, analysis, to disregard the effect on consumers. One is using it to take a longer view or a wider view on the sets of outcomes that will or might substantially lessen the well-being of consumers. So I think that this is a really fundamentally important point. These ideas are not in opposition. One could view them as simply two ideas perhaps operating in along a time continuum.
So Doug's had his hands up for a while, and I know that Nancy has something she wants to say too.
All right, let's do it.
So I think this is a much simpler problem than we're making it. And I'm following on, I guess, something that Kyle said. First of all, consumer welfare was a very clever political term used by Bork to sell his movement away from protecting competitors and basically in favor of maximizing welfare or avoiding dead weight loss, or whatever, however you might really articulate what his objective was. But analytically, there's no reason to call it, or to intend by it, consumer welfare. It really ought to be thought of as trading partner welfare. Now, Debbie says, well, wait a minute, it really isn't symmetrical, because there are possible efficiencies among the merging firms in the upstream market, and they could benefit consumers, to which I think there are a couple of answers. First of all, if there are efficiencies in the normal sense, the mirror image is available to you, because you would expect them to be increasing output and benefiting their trading partners, just as if there are mergers that benefit downstream trading partners in the form of lower prices because of the efficiencies, we say, okay, this merger gets a pass, at least if it's not a merger of monopoly. But if you don't have efficiencies of that nature and you have a harmed trading partner, then Debbie's second question is to say, well, why would these guys do that? That's the same argument that was used to say, why would a distributor agree to an exclusive dealing arrangement if it's going to contribute to the creation of a monopolist he has to deal with in the future? It's not just myopia that would cause him to do it. It's also often a large number of coordination problems and externalities. Because he might not be, if you're the big buyer now, you don't really mind if output is reduced a little bit at the supplier level if you think you're not the one who's going to be hurt by it. So I think there's a very simple model. Steve Salop kind of articulated the legal principle, and as did Nancy, I guess, which is antitrust has never attempted to do a big social accounting and tracing all the effects. It has always said, let's just focus on the market in which the transactions are taking place. If the transaction is going to create deadweight loss or likely to create deadweight loss, it's likely to correlate in the long run with a reduction in aggregate welfare, but life is too short to actually measure that and prove it in the case. Plaintiff wins.
Final thoughts before lunch?
I'll leave it at that.
All right.
That was nice.
Thanks to everybody.
We used to work together at $80 and it was like a good
Yes,